Assalamu alaikum and welcome you all. Students, today is the 10th week of our course, that is the International Criminal Law. So in this class, student, now I'm going to introduce second part of our course, that is the substantial law. In this scheme of lectures or in the series, I am going to deliver my lectures regarding the substantial law of the international criminal law. So before that session, in part one, we have discussed the basic historical perspective, basic introduction, and jurisdiction of the international criminal law. Very much important. There are the tale of two courts. Number one, that is the ICC, and number two, that is the ICJ. Up now, after understanding and after discussing that session, now I'm going to take you in the second part of this course, that is the substantial law of the international crimes. Students, and this is the international criminal law in the program LLM, and you are in the third semester. And as you know, I am Mullah Mujtaba, professor of law in the Shaykh Zafar University of Law. I've situated in the Karachi. And here is the students' second part of our course, that is the substantive law on international crimes. So these are the list of course syllabus and timetable which we are going to. I am giving you a review of that part from today, current week. In this week, we are going to discuss war crimes, and thereafter next week we will discuss crime against humanity, and thereafter genocide, and which followed by the crime of aggression, which is crime against the peace, and thereafter further part of the theories, principles regarding the international criminal law, that is the transnational crimes, terrorism, corruption, and torture, which is the future of the international criminal law. And in that at that connection, the continuation of that lecture, that is the introduction to the corruption and United Nations Convention on the corruption, and thereafter finally I will end my this course lectures with the discussion of the defenses under international criminal law and immunity. So this slide give you a simple introduction of the today's lecture. That is the lesson plan regarding the substantive law of the international criminal law and international crimes. Now I am going to start with the war crimes in this session. This lecture divided in two sessions. In first session, I will give you introduction and thereafter international humanitarian law and the development of the notion of the war crimes. Thereafter, next session, after a break, I will start the topic of the elements of the war crimes and grave breaches of the Geneva Conventions and other serious violation in the international armed conflicts. So, first of all, the what will be the learning of objective of this part and this series of lecture. In this part, you are going to learn to familiarize a participant with the substantive law of the international crime, particularly which the definition of the war crimes, crime against humanity, genocide, crime against aggression, and other international crimes such as torture and terrorism. And this lecture will provide you a basic understanding of the mental and physical elements of the international crimes and other elements which need to be proved in order to establish individual responsibility for the crime. Learning and after understanding this part of lecture, the question probably will comes in your minds regarding what is the substantive law applied to the criminal proceedings, and were the proceedings before an international court or tribunal, or a domestic court, and in case of a domestic trial, did you refer to any international instruments or case law of the international courts or tribunals which define the international crimes? And did you encounter any problem regarding the substantive law of the international crimes, that is, the gaps or impression in their definitions? And what is the outcome of the those cases and those definitions and those theories? So this part of lecture, students, very it is easier to provide a list of international crimes than to provide an all encompassing definitions. The core international crimes are aggression, genocide, crime against humanity, and war crimes. So these are the crimes which are prosecuted with some expressions at the international courts and tribunals, which we have discussed in previous lectures. Aggression, due to its political nature, is by far the most controversial of core crimes, and resultantly, it is such less commonly prosecuted than the other international crimes. While it is relatively easy to list the core international crimes, it is more difficult to define them. In order fully to understand these terms, it is necessary to set out the historical background to the development and elaboration of each of the crimes. We need to consider the concepts of the international humanitarian law, which mean jus in bello and jus ad bellum, international human rights. Uh, these crimes are connected with the other laws of the United Nations or internationally recognized or acknowledged. Those are the international humanitarian law and international human rights law. To understand their sources and to see how these areas of law interrelate and overlap. To give an example of such overlap, war crimes and crimes against humanity may overlap in that a mass killing of these civilians during an armed conflict could constitute both war crimes and a crime against humanity. However, there are important differences between the two type of crimes. In particular, unlike war crimes, crime against humanity may also occur in the absence of armed conflicts. On the other hand, crimes against humanity must be committed as part of wider spread or systematic attack, whereas a single isolated offense can constitute a war crime. Crimes against humanity concerns action directed primarily against the civilian population, whereas war crimes regulate conduct even on the battlefield and against military objectives. Genocide is a relatively modern concept, having been coined in 1945. At its inception, genocide was regarded as a subset of the crimes against the humanity, namely crimes against humanity committed with the intent to destroy in a whole or in a part a national, ethnic, and racial or religious group, as such as it was therefore an aggravated form of the crime against humanity. In the subsequent half century, however, the definition of the genocide evolved its own autonomous meaning to the point where now its elements differ to some extent from those of the crimes against humanity. However, both types of the crimes remain closely related. This part of this part of lecture will also discuss torture and terrorism as international crimes. Torture and terrorism are currently not regarded as core crimes, and they do not per se fall within the jurisdiction of the international courts and tribunals. However, torture and acts of terrorism may be prosecuted at the international tribunals as the underlying crime in a prosecution for one of the core crimes, if even if they may not be prosecuted in their own right. So, in this lecture, the element of torture and terrorism as distinct international crimes will be considered. Therefore, the purpose of this scheme of lecture is to set out and analyze, give analysis the element of the international crime with the particular emphasis on the elaboration of these crimes in the statutes and case law of the ISTR, S, SCSL, and ICC, including the ICC element of crimes, and to examine some of the difficult problems posed by the prosecution of these crimes. Okay, students, after having the introductory discussion on the upcoming topics and further continuation of the course and journey towards our destination, so I'm going to start today's lecture with the first topic of the substantive law of the international crime, that is the war crimes. War crimes can be understood as a serious violation of the laws and custom of the armed conflicts or international humanitarian law. In other words, the rules of international humanitarian law, at least part of it, are criminalized in the law of war crimes. Given this link to the international humanitarian law, this lecture will begin with the introduction to international humanitarian law. This will be followed by the historical account of the emergence and development of the concept of the war crimes. And finally, I will conclude this topic, this lecture, the law of the war crimes, along with the requisite elements relating to the concept of the specific underlying offenses will be discussed. Throughout this lecture, particular emphasis will be placed on the approach taken by the International Criminal Court (ICC). So, students, before discussing the development and elements of the war crimes under international criminal law, uh, before discussing it, we must know, because uh, war crimes are interrelated or interconnected with the humanitarian international humanitarian law. So we must have a know-how and understanding of the international humanitarian law. So, what is the international humanitarian law? As discussed earlier in mm, introductory lecture of this course, international humanitarian law, also known as the law of war or law of armed conflicts, jus in bello, in the body of rules which seeks for humanitarian reasons to limit the suffering caused by the warfare and to alleviate its effects by the protecting and assisting its victims as far as possible. International humanitarian law, however, does not regulate whether and when a state may actually resort to the use of force, jus ad bellum. Therefore, the question of whether the resort to force was unjustified or illegal has no bearing on the application of the international criminal law. to an armed conflict. So, what is the International Humanitarian Law (IHL)? IHL is a set of rules which place restriction on the use of weapons and methods of the warfare. It also protects people who are not or are no longer participating in hostilities. International humanitarian law uh, goals to protect human dignity and to limit suffering during the time of war. Historically, combatants have always been restricted in the manner in which they conduct armed conflicts. For instance, through treaties or agreements, national laws or religious edict, or by time-honored customs. However, these rules and customs varied greatly throughout the ages, throughout the time, as there were no universally recognized set of norms or rules governing armed conflicts. Universal codification of the international humanitarian law began in the 19th century. Since then, states have agreed to a series of practical rules which aim to strike a balance between humanitarian concerns on the one hand and military reality on the other hand. And further, it is necessary to understand humanitarian law and human rights. Humanitarian law pursues the same purpose as the law of human rights, which is to protect the fundamental rights of the individuals, particularly the lives, health, and dignity of the individuals. As the constitution of the words, the basic articles we will have regarding the fundamental rights. So those part of articles, those chapters include or insert in the constitution which are connected with the humanitarian law of human rights. Humanitarian law only applies in a situation of the armed conflicts, whereas human rights generally protect the individuals at all times, in a war and peace alike, which means humanitarian law only applies when there is a war between two states. But humanitarian laws applies all time. I mean, these are the rights which cannot be suspended, which cannot be deprived. However, some human rights treaties permits governments to derogate from certain rights in situations of the public emergency. No derogations are permitted under the international humanitarian law because it was conceived for emergency situations, which is the armed conflicts. In its advisory opinion on the legal consequences of the construction of the wall in the occupied Palestinian territory, the International Court of Justice held. I'm going to read out those words which are mentioned in the decision of the ISJ. The court considered that the protection offered by the Human Rights Conventions does not cease in case of the armed conflict, save through the effect of the provisions for derogation of the kind to be found in the Article 4 of the International Covenant on the Civil and Political Rights as regards the relationship between the international humanitarian law and human rights law. Human rights law, there are uh, therefore three possible situations. Some rights may be exclusively matters of the international humanitarian law, others may be exclusively matters of the human rights law, yet others may be matters of the both these branches of the international law. In order to answer the question put to it, the court will have to take into consideration both these branches of the international law. which are the human rights law uh, and international humanitarian law. Thereafter, resultantly, the human rights law and humanitarian law overlap. They both apply in time of the armed conflict. Although the human rights also apply during the peacetime. However, humanitarian law is a specialized body of the human rights law and therefore is applied as a lex specialis. An important difference between the two branches of law is that international humanitarian law requires a degree of reciprocity in that laws of war treaty applies only between those states which are parties to it, whereas a human rights treaty binds any state which is a party to it, irrespective of what other states do. Other states do. So next, as for next topic, so what are the sources of the humanitarian law? International humanitarian law is contained in agreements between states, treaties or conventions, and customary rules, which consists of the state practice considered by them to be legally binding and in general principles. The first modern attempt to codify the existence laws and custom of war was made by the Francis Lieber, a law professor at Columbia University in New York. However, the code known as the Lieber Code did not have the status of the treaty, as it was intended solely for the Union soldiers fighting in the American Civil War. President Abraham Lincoln promulgated the text as revised by the Board of Officers as instructions for the government of the armies of the United States in the field. General Order, although they were binding only on the forces of the United States, they corresponded to a great extent to the laws and custom of war existing at that time. A year later, 1864, the first treaty on the protection of the military victims of warfare was drawn up and signed in Geneva, entitled the Geneva Convention for the amelioration of the conditions of the wounded in armies in the field. Important progress in the development of the international humanitarian law was accomplished during the first and second peace conferences at The Hague in 1899 and 1907. The conferences produced one of the most comprehensive codifications, namely the Hague Conventions of 1899 and 1907, respectively providing restrictions on the means and methods by which states conduct the warfares. The Geneva Convention of 1864 was further reviewed and developed by the Geneva Convention adopted in 1906 and 1929 and Geneva Protocol of 1925. As a result, the atrocities that took place during the First and Second World Wars, the Geneva Convention were updated by the fourth further convention in 1949 and to include further protections. Those protections which developed after the First World War and Second World War, I'm going to read out uh, those developments. Number one, amelioration of the condition of the wounded and sick in armed forces in the field, Geneva Convention number one. Amelioration of the condition of the wounded, sick, and shipwrecked members of the armed forces at sea, Geneva Convention number two. Treatment of the prisoners of the war, Geneva Convention number three. Protection of civilian persons at the time of war, Geneva Convention number four. The Geneva Conventions were further updated by two protocols in 1977, which strengthened the protection of the victims of International Armed Conflicts, Additional Protocol number 1, and Non-International Armed Conflict, Additional Protocol number 2. So, students, in some international humanitarian law, also known as the law of armed conflicts or law of war, can be divided in two branches. There are two branches of the international humanitarian law. Number one, what we have, the crux, the nutshell of this lecture, which we what we have get from the earlier discussion is that there are two branches of the international humanitarian law. Number one, Geneva Law, and number two, Hague Law. Geneva Law, which is designed to protect military personnel who are no longer taking part in the fighting and people not actively involved in hostilities. Number two, Hague Law, which established the rights and obligations of the conduct of the military operations and limits the means and methods of the warfares. So, Geneva Law is the body of law comprised of the Geneva Convention of 1864, 1906, and 1929, and their successors, the four Geneva Convention of the 1949 and two additional protocols of 1977 supplement 1949 conventions without repealing them. So these are the statutes and these are the treaties which govern the those articles, those protocols govern the international humanitarian law and war of crimes. And other one, Hague Law, is the body of laws comprised of Hague Convention 1899 and 1907. In particular, the 1899 Convention 2 with respect to the laws and custom of war on land, and the 1907 Hague Convention 4 respecting the laws and custom of war and land with the regulation annexed thereto. The great part of the Hague laws has been incorporated into the additional protocols of 1977. The great part of Hague law, where it has also been further developed as far as they were not incorporated therein, the Hague provisions are still in force. So, students, the Geneva Law and Hague Law are interwoven with each other, and as a result, they have merged into a single complex system which called international humanitarian law. This interrelationship finds expression in the provision, the additional protocol of 1977, which combined both branches of the international humanitarian law. So these are the sources of the international humanitarian law, which are the, in the simple words, the nutshell of this discussion is that the sources of the international humanitarian laws, there are two sources. Number one, Geneva Convention. Number two is the Hague Law. And both collectively we call both the international humanitarian law, which actually govern or enforce the atrocities which can be eradicated, which can be stopped by the states which are involved in on conflict, but those law ensure that no state will violate those laws which are defined in the Geneva Convention and the law of Hague. So I will suggest you further discussion, further study and detailed understanding of these conventions. So you have to gone through in the length of all the articles or provisions of those conventions, which I already mentioned point by point, and I also give you a particular convention with a year, with a protocol, with a number. So when you will unfold those conventions, you will find great knowledge regarding the work, regarding the violations of the armed conflicts and humanitarian laws. Our next topic is that what will be the scope of the application of the international humanitarian law. And this is very much important. International humanitarian law will generally apply only to armed conflict. International humanitarian law, therefore, does not apply to situation of the internal disturbances and tensions, such as riots, isolated and sporadic acts of the violence or other acts of the similar nature. With regard to the armed conflict, international humanitarian law distinguishes between the international and non-international armed conflicts or civil wars. So these are, I'm going to read out these distinguishes one by one. Number one, what is the international armed conflict, non-international armed conflict, and internal disturbances. So what will be the difference? It is very much important to understand what is the international armed conflict: fighting between the armed forces of at least two states. Wars of the national liberation is defined in the Article 1 of the Protocol 1, are classified as international armed conflicts. And what is the non-international armed conflict? Fighting on the territory of a state between the regular armed forces and identifiable armed groups, or between armed groups fighting one another, to be considered a non-international armed conflicts. Fighting must reach a certain level of intensity and extend over a certain period of time. And last one, internal disturbances. Serious students, a serious disruption of the internal order resulting from acts of the violence, which nevertheless do not constitute an armed conflict, which are riots, struggles between the factions or against the authorities. For example, international humanitarian law applicable to the international armed conflicts, which differs from that applicable to the non-international armed conflicts. Determining which laws or principle apply will therefore depending on the classification of the conflicts. International armed conflicts are subject to the wide range of rules, including those acts out in the 4 Geneva Convention and Additional Protocol number 1. A more limited range of the rules apply to the internal armed conflicts and are laid down in the Article 3, common to the 4th Geneva Convention, common article, which is Article number 3, as well as an additional protocol. It should be noted that the condition of the application of the Protocol 2 are stricter are strict than those of the common article number 3. International humanitarian law will come into effect once a conflict has commenced and will apply equally to each side. So, students, now I'm going to give you the idea of the general principle of the international humanitarian law. The general principle of the international humanitarian law may be summarized as follows. I'm going to read out the principles one by one. Number one, protection of the non-combatants. Non-combatants must be spared from the various forms of the harm, which means civilians. The prohibition extends to the civilians and military personnel rendered because they are wounded, sick, and shipwrecked, detained, or have surrendered. Next principle, that is the distinction. Combatants must be distinguished between the military and non-military objectives and attack only military objectives. Principle of the proportionality. Combatants must be endeavored to avoid or minimize collateral civilian damage and are prohibited from the engaging in acts which would cause excessive civilian damage, which is include, for example, long-term damage to the environment. And the last principle, that is the principle of humanity and necessity. There are restrictions on the means and methods of the warfare in order to reduce or eliminate unnecessary injury or suffering, which is the banning the use of biological or chemical weapons. In 1899, Fyodor D. Martens, a prominent jurist and Russian delegate to the 1890 Hague Peace Conference, laid down the principles for cases not covered by the humanitarian law, which designed to fill in any gap between the express provisions, treaty law, and basic precepts of the humanity. This principle, which is considered a part of the customary law, was incorporated in Article 1, Sub-Article 2 of the Additional Protocol of 1977. And I'm going to read out the contents of that protocol. In a cases not covered by this protocol or by other international agreements, civilians and combatants must remain under the protection and authority of the principle of the international law derived from the established custom, from the principle of the humanity, and from the dictates of the public conscience. And students, the most basic rules of the international humanitarian law. There are seven fundamental rules form the basis of the Geneva Convention and the additional protocol. Number one, persons hostily combat and those who do not take a direct party in the hostilities are entitled to respect for their lives and their moral and physical integrity. Number two, it is forbidden to kill or injure any enemy who surrendered or who is a hostile combat. Number three fundamental principle: the wounded and sick shall be collected and cared for by the party to a conflict which has them in its power. Protection also cover medical personnel, establishments, transport, and equipment. Number four, captured combatants and civilians under the authority of an adverse party are entitled to respect for their lives, dignity, lives, dignity, and personal rights and convictions. They shall be protected against all acts of the violence and reprisals. Next, everyone shall be entitled to benefit from the fundamental judicial guarantees. No one shall be held responsible for an act that he has not committed, and no one shall be subjected to physical or mental torture, corporal punishment, or cruel and degrading treatment. Number six, parties to a conflict and members of their armed forces do not have an unlimited choice of the method and means of warfare. Number seven, and the last fundamental principle: parties to a conflict shall at all times distinguish between the civilian population and combatants in order to spare civilian population and property. Neither the civilian population as such nor civilian persons shall be the object of the attack. Attacks shall be directed solely in against the military objectives. So, students, these are the principles which uh, very much clear. It is the moral, and it is the ethics, and it is the humanitarian basis that when any conflict occurred, those those persons and those things should be avoided during those conflicts means innocent civilians, childs, women, and senior persons, and their lands, environment should be protected during warfare. And those combatants, those soldiers who surrendered, they are also they do not harm them, do not torture them physically, mentally. And they also provided the all the legal rights and other access to those. These are the convention clearly says that. And make the state responsible regarding the inhuman treatment during the conflicts. So history is the full of those bloody and those barbaric acts which happened during the armed conflict. And there are millions of the people killed inhumanly, and lot and during the conflict, lot of women they raped, their properties has been stolen, and other atrocities happened in the history of the war conflicts. So ultimately, when states gathered and the prudent mind sit in the conferences, then these laws has been formulated uh, in order to make the state responsible, and only attack on those objects which are restrain those states, their armies, their soldiers from the attack on the innocent persons, their properties, and do not destroy the environment.